Our viewers at home, indeed what happened is that the public protector lost her appeal on the Estina Diary Farm ruling matter, and then she has indicated that she will then be approaching the Supreme Court of Appeal directly to petition the court and hopefully come to a different conclusion as to whether her report on Estina Diary Farm was indeed invalid.
Sipho, were there reasons advanced as to why she lost that appeal?
Well, the court found that she did not present a strong enough case to indicate that a higher court would come to a different conclusion, and this is based on two matters, and one of those matters is the case itself, that is the report, but also the other matter is the personal cost order against her. The court found that the decision that it has taken to grant the personal cost order against her and to declare her report invalid, those decisions were correct in law, and that her appeal just simply did not meet the criteria for the court to approve it and allow her to go appeal the case.
Sipho, it's my understanding that the public protector spoke at some point about a dangerous precedent being set when personal cost orders are granted in matters like this. Was that touched on today in court?
Well, the public protector feels strongly that the issue of personal cost order against her makes it difficult for her to do her job, in the sense that now when she makes decision, she has to worry about the possibility of incurring a personal cost order. She says this is then getting in the way of her doing her job, and she did try to argue this matter in court, but the court found that, well, if you had done your job in the initial report properly, then you wouldn't be in a position where now you are liable for personal cost order. So the court had found that she did not do a thorough job in the Estina Diary Farm report, and that senior politicians that were implicated were let off the hook, and that essentially she failed the poor people of Free State in the manner that she conducted that report. And the people that were said to benefit from this project, it cost about 300 million rand, and there was really no big names or senior officials that were implicated here. All that she said was that the then Free State Premier, that is Isma Khashule, needs to discipline those that were involved, but no big fishes that were really implicated in this matter. And a lot of the parties that were part of these proceedings really complained to say, well, this is a whitewash. You know, the big fishes here, the people that were behind the looting of this project were really not implicated. So it was the CASAC and the DA that took this matter to court, and then they won this court because the court overturned that report and said that it was invalid. But subsequent to the ruling that the report was invalid, then there was also a cost order that she was ordered to pay 7.5% personally of both councils. And this was the second time that she was also granted or slapped with a cost order. It had happened before with the Absa Bank matter, and now she was also granted again with personal cost order. And then she has spoken strongly against this, to say this is not how she's supposed to function as the head of a Chapter 9 institution, being slapped with cost orders. Then it inhibits her work, and that now she will then work with this threat and anxiety that if I get it wrong, then I'm going to be slapped with personal cost order, and she feels that is not how it should be done.
Sipho, earlier on you said that she was going to try and take this further, but we know that previously Justice Kampepe said there must be a material misdirection of a lower court if the higher court is going to change what's happened in the appeal. So did you have an indication of how the public protector thinks she can take this matter further if it is, according to this court judgment, sound in law?
Well, the public protector disagrees fundamentally with Judge Ronel Tolmei. She's stated that even the language that was used by the judge to describe the public protector, she was very unhappy with how her work was described by the judge. So they come from different train of thoughts, the two. But she says then she is, of course, entitled then to petition the Supreme Court of Appeal directly. But as the process then required that she must first then appeal to the same court, and if she has lost that appeal, then she must then go ahead and appeal to the Supreme Court, petition rather the Supreme Court of Appeal. She is entitled to do so. It's part of her legal recourse, and she says that she's going to exhaust every available opportunity because she feels that the judge here has strongly erred in the sense that They've granted her these personal cost orders, and not only that, her report, the finding that her report is invalid, she feels that her report is actually, it's valid, and that she did the best that she could with the limited resources that she had, because she spoke a great deal about having limited resources and the fact that she did not have the necessary funds and support to have had a broad and wide scope investigation. We now know, of course, that she will then be conducting a second part of this report, because she said that due to the limits, she only had to then release that first part of it, which was looking at the complainants on whether, rather how the dairy farm project was run, but she said she didn't have enough facilities to be able to go for the big guns, the politicians or so. That it will come as part B of this investigation. But certainly she feels strongly that part A of her report, the one that she's released, that is correct in law, and that a different court will come to a different conclusion than the High Court here in Pretoria.
Sipho Stuurman giving us an update on the Public Protector's loss.